Hello, I'm Scott Brown with Scott Brown and Associates. Today we're going to discuss, should I take a plea deal or take my chances at trial? There is no one-size-fits-all answer to the question, should I take the deal or take my chances at trial? Your answer will depend on your evaluation of a number of different legal and personal factors, which I will outline for you in this video. How you weigh these factors will depend on your unique circumstances. So let's dive in. As you contemplate the prosecutor's offer, key factors to consider are, number one, the charges against you and the sentence you face if you are convicted. How serious is your alleged crime? Are aggravating factors involved? Do any charges carry a mandatory minimum sentence? What is the total sentence on all charges to which you are exposed? In addition to any sentence imposed, what are the potential collateral consequences of a guilty plea? A guilty plea entered as part of a plea bargain is the same as a criminal conviction in the eyes of the law, and you will be subject to all the consequences that accompany a conviction. Depending on your situation, this might include immigration-related consequences, employment-related consequences, loss of your professional license, loss of voting privileges, loss of driving privileges, and loss of the right to possess firearms. Number three, how strong is the evidence against you? What will the prosecution witnesses say? Are the witnesses credible? Will they appeal to a jury? What type of physical evidence does the prosecutor have? Can any of the evidence against you be suppressed? Police officers sometimes overreach. If the officer's conduct in connection with your arrest and/or in gathering the evidence against you violated your constitutional rights, your defense attorney can ask a judge to throw out or suppress the unlawfully obtained evidence. If the evidence is tossed, it may weaken the prosecution's case to such an extent that the charges against you will be reduced or perhaps dropped altogether. Number four, a fourth factor to consider is the nature of the offer itself. What exactly is the prosecutor offering? To allow you to plead to lesser charges? To drop one or more charges? To recommend a reduced sentence or a release from custody with a sentence of probation? In exchange, what is expected from you? Are you being asked to turn state's evidence and cooperate with the prosecution? If the deal includes jail time, how much? What are the proposed terms of probation? Number five, personal factors will weigh heavily into your decision to take a plea deal or go to trial. You will want to think about your age, your health, your family situation, your financial situation, your criminal history, if any, your desire to keep this matter private, and importantly, your willingness to take risk. Juries are unpredictable. Even if you believe you have an open and shut case, a jury might not see it that way. Are you willing to let a group of strangers decide your fate? Are you physically, mentally, and emotionally prepared to endure a stressful trial? Or are you ready to put a difficult situation behind you and move on with your life? Number six, one final factor to consider in making this heavy decision is the advice of counsel. A knowledgeable and experienced criminal defense attorney can help you make an informed decision based on a realistic and honest assessment of the terms of the deal, the charges against you, the evidence against you, the likelihood of a conviction, the sentence you are facing, your personal situation, your ability to stand up to a trial and the possibility of a guilty verdict, and intangible factors like the reputation of the prosecutor and the judge and the tendencies of local juries. The decision to take a plea deal or take your chances at trial belongs to you alone, but that doesn't mean you have to make it alone. If you or a loved one is facing criminal charges, call us here at Scott Brown and Associates.